Georgia's top election leader testifies. An investigation by the Fulton County District Attorney now digging for clues about whether former President Donald Trump illegally meddled with votes in the 2020 election. CBS 46's Adam Murphy live at the Fulton County Courthouse with the high-profile proceedings. Good evening.
Good evening, Sean. I'll tell you, the Secretary of State arrived here at the Fulton County Courthouse early this morning, telling our cameras he hoped that testimony would go quickly, but he was here for several hours, not wrapping up his testimony under oath until about 3 o'clock. Early Thursday morning, Georgia Secretary of State Brad Raffensperger walked into the Fulton County Courthouse to testify before a special grand jury, looking into former President Donald Trump and his alleged attempt to overturn the 2020 election.
I think we can take away the fact that he's obviously a critical witness. I mean, he was the one on the other side of the call.
Trial lawyer Tom Church said the case will boil down to the president's intent on the call.
Okay, so this is potentially the most significant constitutional confrontation over presidential power that we've seen during Trump's entire second term, and the implications could fundamentally reshape how the pardon power works for every future president. The Supreme Court is now confronting a situation where Trump issued a sweeping blanket pardon for everyone involved in the 2020 election schemes, but his own Department of Justice is telling courts that specific defendants aren't actually covered, meaning Trump's pardons may not protect the people he claimed they would protect. This creates an extraordinary showdown between the president's clemency power and his own executive branch officials, who are apparently limiting that power in ways that could gut Trump's ability to shield his allies from prosecution. But before we go any further, real quick, let's be honest. You can't really trust headlines anymore. That's why we built Pump Politics to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
780 votes, which is one more than we have, because we won the state.
The intent of the call is information the Secretary of State is likely to provide to the grand jury.
He's the one who can provide the context to the call. And notably, the subpoena sent out asked for not just his testimony, but for documents.
Let me walk you through what's happening, because the legal maneuvering here is genuinely unprecedented and the stakes couldn't be higher. On November 7th, 2025, Trump issued a blanket pardon covering all United States citizens for conduct relating to 2020 election challenges. The language was deliberately broad, designed to protect everyone who participated in the fake elector schemes, the pressure campaigns on state officials, and related activities. Trump wanted comprehensive coverage that would reach anyone who helped him try to overturn the election, whether they were named specifically or not. But now, in the Matthew Lace case, the Department of Justice has filed papers in federal court explicitly stating that Lace is not covered by President Trump's November 7th pardon proclamation. That's Trump's own Justice Department, led by his own Attorney General Pam Bondi, telling a court that Trump's pardon doesn't apply to someone who participated in exactly the conduct the pardon was supposed to cover. The interpretation is coming from pardon attorney Ed Martin, and DOJ is arguing that Martin's view should get high deference from the courts. Come on, think about what this means. Trump issued a pardon that he told everyone would protect all participants in the 2020 election schemes. His allies relied on that promise. They structured their legal defenses around the assumption that they were pardoned. And now Trump's own DOJ is saying some of them aren't covered after all. The pardon that was supposed to provide certainty is instead creating chaos, with Trump's own appointees deciding who gets protection and who doesn't. The constitutional problem at the heart of this situation is profound and has never been tested before. The pardon power belongs to the president personally under Article 2 of the Constitution. It's one of the most absolute powers the Constitution grants to any single official, but Trump's blanket pardon was so broad and so vague that it essentially delegated the actual decisions about who's covered to subordinate officials in the Justice Department. Former pardon attorney Liz Oyer has explained that the decision has to be the president's. It cannot constitutionally be delegated to DOJ officials, who then decide case by case whether someone qualifies. The hearing before Judge Joseph Leeson, scheduled for Monday, could establish precedent that shapes the pardon power for generations. If the court accepts DOJ's position that subordinate officials can interpret and limit blanket pardons, it means presidential clemency is only as strong as the bureaucrats implementing it. If the court rejects DOJ's interpretation and requires the pardon to be applied as written, it could force recognition of coverage for anyone who participated in the described conduct. Either way, the ruling will have massive implications for how broad pardons work. This situation exposes cracks in Trump's impunity strategy that connect directly to everything else we've been covering. The self-pardon discussions, where Trump explored pardoning himself but apparently concluded he couldn't. The Hernandez drug lord pardon that showed he grant clemency to a convicted cocaine trafficker, but somehow his election allies can't get clear protection. The DOJ gatekeeping that's leaving people who thought they were pardoned facing continued prosecution. Trump's entire approach to using the pardon power as a shield for himself and his allies is running into limits, some self-imposed, some imposed by his own officials. The 50-plus pardons Trump has issued since returning to office in January 2025 represent an aggressive use of clemency power that already raised concerns. The January 6th blanket pardon on day one, the pardons for allies like Giuliani and Powell, the Hernandez drug lord pardon, all of these were controversial. But this situation is different because it's Trump's own DOJ undermining his own pardons. The conflict isn't between Trump and his opponents, it's between Trump's stated intentions and his own administration's implementation. The political implications are enormous because this affects real people who made real decisions based on Trump's promises of protection. If you participated in the 2020 election schemes believing the blanket pardon covered you, you're now discovering that protection may not exist. You may still face prosecution. You may still go to prison. Trump's promise was illusory, and his own officials are the ones making it so. What does that do to loyalty calculations for anyone considering helping Trump in the future? The timing with other pardon controversies compounds the chaos. The Hernandez pardon showed Trump will free a convicted drug trafficker who took bribes from El Chapo, but Americans who helped with Trump's election schemes might not be protected despite his blanket pardon. The inconsistency is jarring and suggests pardon decisions are based on something other than coherent principle. They're based on whatever serves Trump's immediate interests, with implementation left to officials who may have their own views about who deserves coverage. So in this video, we're going to break down exactly what DOJ is arguing and why it creates such a constitutional crisis. We're going to examine what happens if courts accept or reject DOJ's interpretation. We're going to look at what this means for Trump allies who thought they were protected, and we're going to discuss how this potential gutting of the pardon power connects to the broader pattern of Trump's legal and political troubles. Let's get into it. All right, let's get into the specific legal arguments and why this confrontation over the blanket pardon could produce precedent that fundamentally reshapes presidential clemency power for generations to come. The blanket pardon Trump issued on November 7, 2025, was designed to provide comprehensive protection for everyone involved in challenging the 2020 election results. The language covered all United States citizens for conduct relating to 2020 election challenges, deliberately broad phrasing intended to reach not just the 77 individuals specifically named in the proclamation, but an unlimited number of others who participated in similar activities. Trump's apparent goal was to ensure that no one who helped him try to overturn the election would face federal prosecution, regardless of whether his lawyers knew about their specific involvement when the pardon was drafted. This approach differs fundamentally from how presidential clemency has traditionally been exercised. Normally, the president reviews individual cases, considers specific circumstances, and makes personal judgments about each recipient. The pardon power is understood to be a personal presidential authority that requires individual presidential judgment. Previous blanket pardons, like Carter's amnesty for Vietnam draft resistors, had clearer criteria and more limited scope. Trump's open-ended pardon covering undefined numbers of people for broadly described conduct was unprecedented in its sweep. The problem became apparent when the Matthew Lace prosecution continued despite the blanket pardon. Lace was charged with crimes related to the 2020 election schemes, exactly the type of conduct Trump's pardon was supposed to cover. His lawyers naturally argued that the pardon applied and the case should be dismissed, but the Department of Justice took the position that Lace is not covered by President Trump's November 7th pardon proclamation. The key figure making this determination is Ed Martin, the pardon attorney appointed by the Trump administration. Martin has concluded that the blanket pardon doesn't apply to Lace, despite the apparently broad language. DOJ is arguing in court filings that Martin's interpretation should receive high deference, meaning courts should largely accept his view of who qualifies rather than applying the pardon language independently. This will give a subordinate official effective control over who benefits from presidential clemency. The constitutional objection to this arrangement is straightforward and serious. The pardon power is vested in the president by Article 2 of the Constitution. It's one of the most personal and absolute powers the Constitution grants. While other executive powers can be delegated to subordinates, the president doesn't personally approve every regulation or sign every contract. The pardon power has traditionally been understood to require presidential judgment because clemency decisions are supposed to reflect the president's personal assessment of justice and mercy. When Trump issued a blanket pardon with language so broad that subordinates have to determine application in individual cases, he effectively delegated the pardon decision to officials like Ed Martin. It's Martin deciding whether Lace gets clemency, not Donald Trump. That delegation may be unconstitutional because the Constitution gives the pardon power to the president specifically, not to the executive branch generally. The president must make clemency decisions. They can't be farmed out to bureaucrats. Former pardon attorney Liz Oyer has provided expert analysis supporting this view. She served in the office of the pardon attorney and understands intimately how the clemency process is supposed to work. Her assessment that the decision has to be the president's and cannot be delegated to subordinate officials carries significant weight given her expertise in exactly this area of law. If she's right, Trump's blanket pardon approach is constitutionally defective, regardless of how courts interpret the specific language. The Monday hearing before Judge Joseph Leeson will directly address these questions. The court will have to decide whether DOJ's interpretation limiting the pardon's application is valid or whether the pardon's plain language must be applied as written. This could go several ways, with dramatically different implications for presidential power. If the court accepts DOJ's position and defers to Ed Martin's interpretation, it establishes that blanket pardons are only as protective as the officials implementing them decide. Future presidents could issue broad clemency, but have subordinates limit application in ways that defeat the president's stated intentions. The pardon power would be filtered through bureaucratic judgment rather than being a direct exercise of presidential authority. Trump allies who thought they were protected would remain prosecutable. If the court rejects DOJ's interpretation and applies the pardon language broadly, it could force recognition of coverage for anyone who participated in the described conduct. This would align with traditional understanding of pardons as presidential decisions that take effect as written, but it would also validate Trump's approach of issuing sweeping clemency without individual review, potentially enabling future presidents to pardon unlimited numbers of people for broadly described conduct without ever considering individual circumstances. There's a third possibility. The court could find the blanket pardon constitutionally defective because it improperly delegates presidential power to subordinates. This would mean the pardon is invalid, not because of DOJ's interpretation, but because of its structure. Such a ruling would have enormous implications, potentially invalidating not just this pardon, but calling into question other broad clemency grants. The practical consequences for defendants like Lace are severe regardless of how the legal theory resolves. They thought they were pardoned. They may have structured their legal defense around that assumption, declining to cooperate with prosecutors, not pursuing plea deals, not mounting vigorous defenses because they expected dismissal. Now they're discovering that protection may not exist because DOJ officials have decided they're not covered. The rug has been pulled out from under people who relied on presidential promises. The 77 individuals specifically named in the pardon are presumably safe. Their protection is explicit and doesn't depend on interpretation. But the potentially unlimited number of others who participated in similar conduct and thought the blanket language covered them now face uncertainty. Each person will have to fight for DOJ recognition that they're covered, and DOJ has shown it's willing to say no even when the language seems applicable. The blanket pardon has become a case-by-case determination, defeating its entire purpose. The connection to Trump's other pardon controversies illuminates the incoherence of the current approach. Trump pardoned Juan Orlando Hernandez, a foreign president convicted of trafficking 400 tons of cocaine with bribes from El Chapo's cartel. That pardon went through immediately, no gatekeeping, no questions about coverage. But Americans who participated in Trump's own election schemes, conduct Trump personally encouraged and benefited from, face DOJ officials telling them they might not be protected. The drug lord gets immediate freedom. The election allies get legal limbo. The self-pardon discussions we covered earlier provide additional context. Trump explored pardoning himself during his final days before leaving office in January 2021, apparently recognizing he had criminal exposure. He ultimately didn't issue a self-pardon, possibly because lawyers advised it wouldn't hold up, but the instinct to use clemency as a shield against accountability for himself and his allies has shaped his entire approach to the pardon power. The blanket election pardon was supposed to provide that shield for everyone who helped him. The shield is now cracking. DOJ's gatekeeping creates a two-tier system among Trump's allies that may be intentional or may be bureaucratic dysfunction. Some people were specifically named and have clear protection. Others participated in the same schemes but weren't named, and now they're discovering the blanket language they relied on might not protect them. The distinction isn't based on culpability or circumstances. It's based on whether you happen to be identified when the pardon was drafted. That's arbitrary in a way that pardons aren't supposed to be. The argument that Martin's interpretation deserves high deference essentially asks courts to treat the pardon attorney like an agency interpreting its own regulations. There's legal precedent for deferring to agency interpretations of ambiguous statutory language. But the pardon power isn't a statute, it's a constitutional grant of authority to the president personally. Applying administrative deference doctrines to presidential clemency would represent a significant expansion of bureaucratic control over what's supposed to be a personal presidential power. Okay, So let's break this down into the key points that everyone needs to understand, because this constitutional confrontation could reshape the pardon power in ways that affect every future president and every future use of clemency. Point number one, Trump's own Department of Justice is telling courts that his blanket pardon doesn't cover specific defendants like Matthew Lace, meaning Trump's clemency promises may be worthless for allies who relied on them. The pardon that was supposed to provide comprehensive protection is being limited by the very officials Trump appointed to implement it. Point number two, the constitutional issue is whether the pardon power can be effectively delegated to subordinate officials who decide case by case who qualifies, or whether clemency decisions must be made by the president personally as the Constitution specifies. Former pardon attorney Liz Oyer says the decision has to be the president's, suggesting Trump's blanket approach may be constitutionally defective. Point number three, the Monday hearing before Judge Leeson could establish precedent, determining whether blanket pardons are self-executing based on their language or subject to bureaucratic interpretation that can limit their scope. Either outcome has major implications for presidential power and for the specific defendants whose fate hangs on the ruling. Point number four, the contrast with the Hernandez drug lord pardon exposes the incoherence of the current approach. A foreign cocaine trafficker who took bribes from El Chapo gets immediate freedom, while Americans who participated in Trump's election schemes face DOJ gatekeeping about whether they're covered. Point number five, this situation creates catastrophic uncertainty for Trump allies who made legal decisions based on believing they were pardoned, potentially leaving them prosecutable despite presidential promises of protection. The significance of DOJ officials limiting presidential pardons cannot be overstated for understanding what's at stake constitutionally. The pardon power is one of the few areas where the president's authority is supposed to be essentially absolute. Courts have historically shown extreme deference to clemency decisions. The president can pardon anyone for any federal crime, for any reason or no reason. But if subordinate officials can interpret and limit pardons after their issue, that absoluteness disappears. The pardon power becomes subject to bureaucratic gatekeeping in ways the Constitution never contemplated. The practical effect for people like Lace is devastating and illustrates the human cost of this constitutional uncertainty. Lace structured his legal defense around the assumption that he was pardoned. He may have declined to cooperate with prosecutors because he believed he didn't need their goodwill. He may have not pursued plea deals because he thought the charges would be dismissed. He may have not mounted a vigorous factual defense because he assumed legal proceedings would end once the pardon's applicability was confirmed. Now he's learning his protection may not exist, and he's facing prosecution he thought was impossible. The message to future Trump allies is troubling and may affect cooperation calculations going forward. If you help Trump and he issues a pardon, you might still face prosecution because DOJ officials decide you're not covered. The protection Trump offers may be illusory, a promise that sounds comprehensive, but turns out to have exceptions and limitations imposed by bureaucrats you've never heard of. Why would anyone take legal risks to help Trump if his pardons can't be trusted to actually protect them? The timing with other pardon controversies adds to the perception of chaos and incoherence. Trump pardoned Hernandez, 400 tons of cocaine, bribes from El Chapo, a federal judge calling him a two-faced politician, and that pardon took effect immediately with no questions about coverage. But Americans who participated in election challenges that Trump himself orchestrated faced DOJ telling them they might not be covered despite blanket language that seems to include them. The drug lord gets certain freedom, the election allies get legal limbo. The inconsistency is impossible to explain through any principled framework. The high deference argument DOJ is making would transform how courts review pardons. Currently, pardons are understood to take effect as written, with courts interpreting the language like any other legal document. If courts start deferring to bureaucratic interpretations of pardon scope, it introduces a new layer between presidential intent and legal effect. Future presidents could issue pardons that subordinates, then limit through interpretation, potentially defeating the president's actual intentions. That's not how a personal constitutional power is supposed to work. The connection to the broader pattern of Trump's legal troubles shows the pardon power isn't the shield he thought it would be. Trump explored self-pardon and apparently concluded he couldn't do it. He issued blanket pardons that his own DOJ is limiting. He's using clemency aggressively to reward allies and useful foreigners, but the protection isn't as comprehensive as he claims. At every turn, the pardon power is proving more limited than Trump's rhetoric suggests. He can free drug lords, but apparently can't guarantee protection for his own election allies. For the 2026 implications, this constitutional confrontation could produce rulings and revelations that shape campaign messaging. If courts find Trump's blanket pardons defective or subject to bureaucratic limitation, Democrats can argue his promises are worthless. If allies remain prosecutable despite Trump's clemency, It undermines his image as someone who rewards loyalty. The pardon chaos becomes another example of an administration that can't deliver on its promises, even to its own supporters. The impeachment connection is significant because abuse of the pardon power is precisely the kind of conduct that could support articles of impeachment. If Trump issued pardons that he knew or should have known wouldn't actually protect recipients, that's at minimum incompetence and potentially fraud on the people who relied on those pardons. If DOJ is limiting pardons against Trump's actual wishes, that reveals dysfunction. If DOJ is limiting pardons with Trump's knowledge or approval, it means Trump is betraying allies who trusted his promises. None of these scenarios reflect well on the administration. The precedent from Judge Leeson's ruling will matter long beyond this specific case. If the court finds blanket pardons can be limited by bureaucratic interpretation, future presidents will have to be much more specific in their clemency grants to ensure protection. If the court requires pardons to be applied as written, regardless of DOJ interpretation, it validates issuing broad clemency without individual review. If the court finds Trump's approach constitutionally defective, it could invalidate this pardon and call into question others structured similarly. Whatever the ruling, it will shape presidential power for generations. The fundamental question is whether the pardon power belongs to the president or to the executive branch. The Constitution says the president can grant pardons. It doesn't say the executive branch can grant pardons, subject to bureaucratic implementation. If Ed Martin can decide that Trump's pardon doesn't cover Lace, despite the language seeming to include him, then Martin, an appointee most Americans have never heard of, has effective control over presidential clemency. That's a transfer of constitutional power from the president to subordinates that the document doesn't authorize. Looking ahead to Monday's hearing, the arguments will likely focus on whether the pardon language is clear enough to require application to Lace or ambiguous enough to permit DOJ interpretation, limiting coverage. Lace's lawyers will argue the plain language covers him, and DOJ has no authority to say otherwise. DOJ will argue the language requires interpretation, and Martin's interpretation deserves deference. Judge Leeson will have to decide not just this case, but potentially establish principles governing blanket pardons generally. The chaos this creates is characteristic of Trump's approach to governing. Bold announcements without adequate planning for implementation, sweeping claims that don't hold up under scrutiny, gaps between rhetoric and reality that become apparent only when specific cases test the promises. The blanket pardon followed this pattern, a dramatic gesture that made good headlines, but is now falling apart when applied to actual defendants with actual legal needs. Anyway, that's where things stand with this constitutional showdown that could gut Trump's pardon power and leave allies prosecutable despite his promises of protection. The DOJ gatekeeping that's limiting who the blanket pardon covers. The constitutional question about delegating clemency decisions to subordinates. The Monday hearing that could establish precedent for generations. The comparison with the Hernandez pardon showing incoherent application. And the uncertainty facing Trump allies who thought they were protected. Make sure you're subscribed because Monday's hearing could produce a ruling that fundamentally reshapes presidential clemency power and determines whether Trump's allies actually have the protection he promised them. Whether courts accept DOJ's gatekeeping, whether they require the pardon to be applied as written, whether they find the whole approach constitutionally defective, all of it will have enormous implications for Trump, for his allies, and for presidential power going forward. And if you thought Trump's pardon power was a reliable shield for his supporters, this case shows it may be nothing of the kind. I'll see you in the next one.